afternoon, ladies and gentlemen, and welcome back to our continued discussion of our joint conference. In this session, the topic is recent developments in China's approach to domestic economic governance. And I'm very pleased that we have a very distinguished panel of excellent scholars who have researched deeply on this topic. And I also like to thank our colleagues from Tsinghua University and also at JCICEL for jointly hosting this conference. So we will first, I will first briefly introduce the speaker in the order that they will speak. And we'll leave, so each speaker will talk around 20 minutes and we'll still have about 20 minutes or so in the end for questions. So I'll start by introducing our first speaker, Professor Shen Zhaohui. Professor Shen is an associate professor and doctoral supervisor at Tsinghua University School of Law, member of a special team for the company law revision of the Legal Affairs Committee of the Standing Committee of National People's Congress from 2020 to 2023, member of the Central Legal Committee of China's Democratic League, Deputy Secretary General of the China Business Law Research Association, Michigan U.S. University Grotius Scholar, and he's published many academic papers in the core legal journals. He's also author of the monograph Securities Law, Distribution of Power, editor-in-chief of the Tsinghua Financial Law Review. He's also independently completed many important research projects. So we're very pleased to have Professor Shen with us today, and he will talk about the effect of forthcoming corporate law on foreign invested enterprises in China. Professor Shen, the floor is yours.
Thank you. Thank you, Professor Fan. I'm very, it's my great honor to have the chance to share with you the topic about the effects of the forthcoming company law on foreign investor enterprise in China. China's company law has undergone its second overhaul since 1993. Since China's company law was promulgated in 1993, it has undergone two major revisions and four amendments. The first one is the amendment in 1999, modified according to the rule of state-owned enterprise reform. The second one is the 2004 amendment was made to adapt to the marketization of corporate stock issuance. The third one is that the company, it was revised in 2005, which was overhaul. The outstanding highlights include encouraging investment to establish companies and greatly relaxing controls on the corporate capital system. The 2013 amendment mainly cooperated with the reform of the company registration system to further relax corporate capital systems. And the last one was the 2018 amendment revised the share repurchase system in price. So this one revision of the company law is the second overhaul, started 2018 and is still in progress. So there are some motives for the current round of company law revision. Amending the company law is necessary to deepen the reform of state-owned enterprise And amending the company law is a lead to optimize the business environment and stimulate market innovation viability. Amending company law is the lead to improve the property rights protection system. And the last motive for amending the company law is to improve the basic system of the capital market and promote the development of the capital markets. And the fourth preliminary session of the 18th Central Committee of the CCP proposed that property rights should be protected fairly. Equity is an important property right and should be equally protected. There are also several other important factors contributing to the reform of Chinese company law. Like that, there are 5 judicial interpretations and the manuals of the Nan's People's Congress and the reform of the market entry management and the development of the capital market. All these factors contribute to the reform of the company law. And the last one is that academic research on corporate law theory has many fruitful results. The first amendment draft has been submitted for review and in 2021. And the second amendment draft has been submitted for review. In August this year, the third amendment draft was announced. It is expected the new company law will be published on the end of this year. The next topic is what's the foreign invested enterprise? Foreign invested enterprise refer to enterprise established by foreign investors, where the capital is provided by foreign investors. There are 3 main types of foreign invested enterprise, including WFI, JV, and cooperative JVs. And the foreign investment law, which took effect on January 1, 2020, has replaced the 3 separate laws. The foreign investment law unified the legal regime for foreign invested enterprise. So under the new foreign investment law, cooperative joint ventures will no longer be established and become the history. Today, we focus on how the company law will affect the equity JVs. So what's the characteristics of the joint venture? Often have only 2 shareholders, namely the foreign shareholder and the Chinese shareholder. Often the foreign shareholder brings in technology and know-how, where the Chinese shareholders provide access to the local market resources and land use rights. The JV do not have shareholders meetings, and the company matters are decided by the board of directors. and the Chinese shareholder appoints one supervisor and the foreign shareholder appoints another supervisor. The company has only two supervisors and does not have a supervisory board. The foreign invested enterprise may keep the original organizational forms for 5 years after the effectiveness of the foreign investment law. After the transition period from 2020 to 2024, the organization form and structure and operating laws of foreign invested enterprise are subject to the company law or the partnership enterprise law. That means after 2024, all joint ventures must be reformed or restructured with the company law. Meanwhile, China is revising its company law, which is expected to be passed by the end of this year and implemented on July 1st next year. JVs will have to adapt to the forthcoming company law. Next, I will discuss what impact the company being modified may have on joint ventures. The first effect is about the establishment of JV company. The company law revision draft stipulates that the registered capital of a limited liability company is the capital contribution subscribed by all shareholders. And the capital contribution subscribed by all shareholders can be paid in full within 5 years. 5 years. There are 5 years. The 5 years are the grace period. And in order to prevent shareholders from not paying their capital contribution by the due dates, the revised draft of the company law stipulates a number of special measures. The first one is that the shareholder has the duty to pay the capital contribution in full. The second one is that the company's board of directors discovers that a shareholder has not paid the capital contribution. The board of directors have a duty to issue a written reminder to the shareholder to urge the capital contribution. That means the board of directors calls the capital. And after the call, the company may issue a notice of loss of rights to the shareholder. And the board of directors can make the shareholders' rights void. The third one is that the revised draft of the company law stipulates an accelerated expiration system for shareholders' capital contribution. The fourth one is that if a shareholder transfers equity, the transferee shall bear the obligation to pay the capital contribution. So what's the implications for the joint ventures? The first one is that the shareholders of JV may subscribe the share, but must pay in full within 5 years. The second implication is that shareholders who have subscribed but fail to make the actual payment must fulfill their capital contribution obligations. So that's the first impact. The second impact is that the company law amendment draft introduced the one-tier board. So what's the implications for JV? The first one is that the JV may choose to establish a one-tier board of directors without establishing supervisors board. So the bad news is that because a company with more than 300 employees must establish a director from the employee. Therefore, I think that many JV will avoid the establishment of employee directors. JV with more than 300 employees may not choose the one-tier board corporate governance structure, thus frustrating the good intentions of legislators in promoting the one-tier board mode. And the third point is about the separation of power between the shareholder meeting and the board of directors. According to the company law, every company should have shareholders meeting. But we know that the JV, in the JV, board of directors is the JV company's highest authority. Since the highest authority of existing JV is the board of directors, the corporate governance structure of JV is designed and built based on the logic of the board of directors as the highest authority. However, according to the forthcoming company law, JV should establish the shareholder meeting and the board of directors, and the shareholder meeting have the legal authority, which was the authority of the board of directors of JVs. And the fourth is about the authorized share or capital system. If the JV is a joint stock company, the JV may choose to apply the authorized capital system, which means the company's articles of association or shareholders meeting may grant the company's authority to increase capital to the board of directors. And the fifth is about the reduce of capital. The reduce of capital. Because the amendment draft stipulates that if the company reduces capital, it shall reduce its capital contribution or shares accordingly in proportion to the capital contribution or shares held by the shareholders. So this means if this, it means that foreign investors or Chinese shareholders cannot legally withdraw their investment unilaterally. The sixth point is about the shareholders' rights of the company. This is good news for the shareholders of JV. This means that Chinese shareholders or foreign shareholders of JV have the right to inspect the company's accounting books and accounting documents. This enhanced the shareholders' inspection rights. The next one is about the transfer of shares of the company to the third party. The amendment draft delete the consent rights of other shareholders. This is different from the practice of the JV because we know that according to the judicial interpretation, the shareholders of JV has the consent rights when other shareholders transfer their shares to the third parties. So since the forthcoming company law deletes the consent rights of other shareholders, the judicial interpretation about the consent rights would be void in 2024. This means that Chinese shareholders or foreign shareholders can exit the company relatively freely without the consent of the other party. And the next point is about the liability of the director to third parties. The amendment draft adds an important provision about the director's liability to the third parties. This means that the company's people are even less willing to serve as directors or senior executives, including those of joint venture. And the last one is about the remedies for shareholder oppression. To solve the problem of shareholder oppression, the amendment draft stipulates the one more remedy for the minority shareholder. This means that in JV, there are one more way to solve the problem of shareholder oppression. In summary, after the transition period, JV must comply with company law. By that time, JV will face a new company law. This upcoming new company law will regulate the corporate governance and the governance of joint venture in many aspects, such as shareholder capital contribution, corporate governance structure, the authority of shareholders meeting, and the board of directors, share issuance, reducible capital, shareholder rights, equity transfer, directors' responsibility to the third parties, and remedies for shareholder oppression, and so on. That's all. Thank you. I appreciate your time.
Thank you so much, Professor Shen, for such a detailed and comprehensive analysis of the implications of the forthcoming company law revision to those foreign investment enterprises in many aspects. I'm sure there are more questions. I hope to have time to discuss later. And now I would like to turn to our second speaker. So Dr. Bai Xue, she is a postdoctoral fellow at CIBO. Her research explores different government restraints on competition with a particular focus on how the state-owned enterprises interact with competition law and policy. And she has published very widely in the field, including her recent article published in the Journal of Competition Law and Economics with my colleague Deb and Rhonda Smith. And she was awarded concurrent PhD award in 2002 with her thesis, Reform of Chinese State-Owned Enterprises, What China Can Learn from Practice of Competition Neutrality Policy in Australia, and her book also based on the thesis were recently published. So congratulations for that. I'm very happy to have Dr. Bai with us. So her topic is Fair Competition Review System, the Australian Insights for China.
Good afternoon, everyone. Firstly, I would like to thank you, JCICEL, for your kindly invitation for me to participate in today's panel. And I have learned a lot from our college from Tsinghua and UNSW this morning. And before I begin my presentation today, I would like to acknowledge that my presentation today is largely based on a co-authored article with Professor Deborah Healy. So thank you, Professor Deborah Healy. And due to today's time limitation, I would briefly touch upon three main points. First is, what is competition impact and why does it matter? Second is how does China's fair competition review system operate in practice, and what are the potential issues that limited its full potential? And in the end, I will touch upon what are the lessons from overseas on such a review. Let's begin on what is competition impact and why we care about it. For audience who is not familiar with competition law and policy, competition is a process of rivalry between firms, and when it is effective, encourage firms to deliver benefits to consumers in terms of lower prices, higher quantities, and more choices. Competition more in the market is a key driver for great value, innovation, and productivity, and therefore it's better outcome for consumers in general. And the government everywhere face complex financial, environmental, infrastructure, and social policy challenges. And sometimes regulation is a key instrument to draw on to address those issues. Government policy and action in market is often motivated by important goals rather than just promotion or protection of competition. However, without careful consideration, government regulations may unnecessarily restrict competition in the market and therefore can impact consumers' productivity, growth, and innovation in the market. The anti-competitive effects of laws, policies, and regulations on market has long been highlighted by international organizations such as OECD. So to achieve a better regulatory environment and ultimately create a unified national market, competition impact assessment is a process designed to assess the effects of regulation, both new and existing ones, on competition. So government everywhere are increasingly interested in competition impact assessment. Both UK, New Zealand have their own competition impact assessment guidelines in place, and our OECD members have adopted regulatory impact assessment. You may wonder, so what is the difference between competition impact assessment and regulatory impact assessment? As you can see, I provided the definition on my PowerPoint. But in general, regulatory impact assessment aims to ensure that policy development process consistently delivers regulation or other policy solutions that provide the greatest benefit to the community relatively to overall cost imposed. By contrast, competition impact assessment is a quantitative study to the adverse effect of regulation on competition. So put it really simple, well, competition impact assessment, as the name suggested, study mainly on competition impact of regulation, while the competition impact of regulation is only one element being considered in regulatory impact assessment. So based on this definition, as you can see, fair competition review system in China is a form of competition impact assessment. I provided the definition in my slides as suggested. Fair competition review rested on the promises that government authorities should not issue policies that restrict competition unless it is justified on the ground of national security related circumstances, social security purpose, public interest, and any other circumstances prescribed by law and regulations. And I would like to say the implementation progress of fair competition review in China is very impressive, which reflects on the commitment of Chinese government to competition. For example, based on the statistic from state SAMR, our Chinese competition authority, 244 new policy as measures document has been reviewed nationwide in last year, in 2021. And 442,000 policy documents has been cleared up, and 11200 documents that violate the new review standards has been corrected or repealed. So this is very impressive. And the process of fair competition review has been fostering competition awareness among our government agencies. So how does fair competition works in practice? I will briefly mention the scope exemptions, institution involved in the process, and the standard of review, and what are the outside mechanism for such a review system. Each country has their own assessment of what type of regulation should be subject to review. OECD, as you can see, proposed a range of regulation subject to assessment, include laws, formal and informal orders, subordinate rules issued by all levels of government, and rules issued by non-governmental or self-regulatory bodies to which government have dedicated regulatory powers. By comparison, the scope of fair competition review is relatively narrower than the coverage of OECD suggested. It does not cover all legal instruments in China. I listed what fair competition review covers at the bottom of my slides. As you can see, the reason for this scope, I think, it is because regulatory restrictions to a united domestic market in China and fair competition often come from regulations rather than legislations, as years of enforcement of administrative monopoly suggested. And for institutions involved in fair competition review, I would like to say the role of fair competition review, the role of competition authority is especially state administration for market regulations SMART. While it is like suggested by OECD that competition regulators within a jurisdiction would be ideal have a formal role in the review process because it's knowledge and understanding of competition. However, few competition regulators have direct role involved in the review process. In China, at least, fair competition review is conducted according to the principle, whoever formulates a policy shall be responsible for policy review. In this sense, our competition authority is SMART, especially its fair competition review division, is often associated with fair competition review via competition advocacy and sometimes competition training and also some auditing, which I will address later. The reason for this design, from my understanding, is pretty straightforward. Requiring the competition authority to undertake such a review would demand a huge amount of human resources, the weight of regulatory burden, and the potential enforcement cost imposed on the Chinese competition authority to oversee such a review would be really heavy, and thus make such authority undesirable body to conduct such review. And as the role of policy-making bodies, they shoulder the responsibility of conduct such review. As the principle suggested, whoever formulates the policy shall be responsible for review. However, in China, like for policy measures that jointly formulated and introduced in the name of multiple departments, the lead department is responsible for such a review. This means, in practice, a public servant, especially the one in charge, would be personally responsible for the quantity of review in their department. There are, however, to the best knowledge of authors, no case reported publicly on public servants being held accountable for non-compliance of such review. Whether the design of current sanction for non-compliance are effective way to encourage compliance will need more empirical evidence to tell at this stage. And it was worth mentioning the role of third party. And the third party, what I mean is an independent third-party institution, such as institution of higher education, research institution, professional consulting firms, law firms, and other non-governmental organizations can be invited to be involved in the review process. The cost of third-party assessment should paid by government budgets. Local level government procedure varies considerably on whether third-party mandate or what matter should trigger such evaluation. And also it worth to mention government has discretion on whether to adopt the recommendation provided to the third party. However, if a government decided not to adopt a recommendation by the third party, they are obliged to provide a written document on why, explain the reason. And for the rule of inter-ministerial joint meeting system, as I mentioned, there are in China sometimes rules are formulated in multiple departments, and the inter-ministerial joint meeting system has been established for coordinate, supervise, and guide fair competition review works. One particular function for this joint conference system is to coordinating multiple departments on fair competition review matter when dispute happened. And for standards of fair competition review system, as you can see, I probably won't go into details of standards due to the time limitation. In general, the assessment factor listed in fair competition review largely corresponding to the factor listed in OECD competition assessment checklist. For example, market entry and exit assessment and free circulation of good and commodity factors listed under the fair competition review falls into the scope of limits the number of range of suppliers under the OECD competition assessment checklist. So, and with the oversight of mechanism of fair competition review is essential for the compliance. Under the fair competition review system, government not only are required to conduct such a review, it will also be asked to carry out a peer review of their fair competition review performances. This ex post review is complementary for the ex ante review. And also, as I said, SMART also in competition authority SMART also involved in this process, as SMART conduct a selective audit on implemented policy measure to assess whether the selected policy measure has been reviewed and documented, whether the review standards has been applied adequately, or whether the review process followed the due process. They can also provide feedbacks to government that is being audited, and government should respond to that. Enforcement under the fair competition review system. And China adopts, as you can tell, China adopts an administrative approach to handle the complaints. This means anyone, firms or individuals can either complain directly to the policymaking authority or lodge a tip-off to the superior body of policymaking authority. However, the details rules on how to handle such complaints is determined by each level of government in China. Complaints can be made anonymously but provide relevant facts, evidence in writing. However, fair competition review complaint handle bodies in some cities noted that complaints handle department made anonymously. Find that the factors, potential issues that limited the full potential fair competition review system in China. In brief, if the objective of a fair competition review system is to enhance fair competition, and ultimately ensure a unified Chinese market, then there are some issues that preventing it to achieve its full potential. First point is, while the application of the fair competition review system is broadly in line with the principles set out by the regulation, we discovered there are a wide range of different procedure approach at local government level. An important issue is how to ensure requirement under the fair competition review are not inconsistently applied across the country. Second point is, in particular, exemption requirement under the fair competition review creates a heavy compliance burden on government bodies seeking such exemption. In terms of staffing, especially staff with certain amount of knowledge on competition at local level, it's hard to locate. And the actual exemption procedure and how such exemption is used in practice is rare made in public, even though the granting such exception required by law to be made public. And there is a great uncertainty about the application of exemptions for the purpose of fair competition review system. And this way, we think, may reduce the effectiveness of fair competition review in achieving unified national market. And lastly, the effectiveness of sanction for fair competition review for non-compliance needed more case study, as I suggested before. It is generally accepted that having complied, however, the government responds to such a review. In addition, government agency, especially the person directly in charge of the agency, will be held accountable for not complying. So how such accountability is used in practice is worth further attention. So which brings me, I will wrap it up very soon. I'm very conscious with the time. What are the lessons from overseas? Australia has been implemented regulatory review over 30 years. The Commonwealth, each state and territory have all established their review system for new and amended regulation, which is designed to improve quality of regulatory decision by providing relevant information to decision makers and stakeholders about the expected consequence of different policy opinions. So in brief, the lessons can draw from Australia's practice is what is relevant to China here. I would like to point out is exemptions should be transparently justified in a written decision. And I would like to say culture shift with organization take a number of years, and also penalty for non-compliance are useful. So this is the end of my presentation, and thank you for listening. And I would like to say thanks again for the effort both Sibo Center and Tsinghua Law School put into this conference. And I provided my website as a QR code, so you can find me easily. Thank you.
Thank you so much, Bai Xue, for the very insightful presentations. And we hope to come back to you also for some questions later. I will now move to our third speaker, Professor Tang Xin. Professor Tang is a professor at Tsinghua University School of Law and director of Tsinghua University Law School Commercial Law Center. Professor Tang's interests focus on capital market law and comparative corporate governance. He has published widely in the field of protection of security market investors, fiduciary duties of directors and controlling shareholders, minority shareholder litigation, merger acquisition of listed companies, legal liability of market abuse. He's also visited and taught at leading universities in the US and Israel. Professor Tang served as a member of the Merger and Restructuring Review Commission of China Security Regulatory Commission. He's now sitting in the listing board of the Shanghai Stock Exchange. So Professor Tang today will talk about theoretical reconstruction of civil liability for insider trading under PRC securities law.
Okay, thank you very much. And also thanks the invitation from Tsinghua UNSW Joint Research Center for this opportunity to make the presentation. As you can see, the topic of today from me is theoretical reconstruction of a civil liability regime. And this presentation is actually based on a draft paper already. And the co-author with me is Mr. Li Zhaohui, who is not over here today. It will be a theoretical paper under which reasonableness or justification for a civil liability regime under the PRC securities law about the insider trading liabilities. And in the paper, we cover all these chapters. First of all, the theoretical controversy, which make this paper and its research useful analysis of insider trading civil liability jurisdictions or models. Well, research the models of EU, of Germany, of US, and also the model of China itself. And in the third part of the paper, we argued for a so-called dual protection model under China's securities law. And finally, we reach the conclusions. Firstly, the theoretical controversy. Anyone who is familiar with the securities law of China, with the newest revisions in 2019, will know that there is a particular article about insider trading. And under the PRC law, insider trading is illegal. And apart from the possible administrative sanctions and also criminal law penalties, under Article 53 of the PRC securities law, there may be even civil liabilities. That means the damaged investors from the insider trading would be subject to compensations from the perpetrators of the insider trading. But the problem is quite a lot of scholars argue for this regime of civil liability, that a reasonableness or justification of such a civil liability clause under the PRC law. And some of them even argue that such kind of regime should be absolutely deleted. So it is the objective of this paper to argue for the justification of this regime. And to achieve this objective, the paper cover all the theories, the theoretical controversies, and take a look at the inside or the core of the doctrinal debate. So one of the major theory for the insider trading civil liability regime is the anti-fraud theories. Quite some scholars would argue for this theory, and it is also embodied with one of the earliest administrative measures from China's securities market regulator for prohibition of securities frauds as early as in 1993. But the problem is the anti-fraud theory would fail to list the necessary details for the regime itself. It failed to illustrate clearly why the regime should be over there and should be justified. So there has already been scholar criticism against this theory, although this anti-fraud theory would be the mainstream theory for the anti-insider trading civil liability regime itself. And there is another theory for the regime of civil liabilities. That is so-called information equality theory. Some scholars would argue for the theory, some would argue against it. The problem of this theory is it has some inherent dilemma in itself, especially around the causation element, which is critical for a civil liability regime as a tort. If you would deem that insider trading is a tort and it should be compensating liability under the tort theory, then you must prove that there should be causation between the illegal action of the perpetrator and the losses of the investors. But the problem with the information equality theory is it failed to illustrate such kind of causation. And it also failed to argue for that particular investors should be protected for under the securities law. Because in the basic of this information equality theory, the law over there to run against insider trading is for the whole integrity of the market instead of the particular interests of particular investors. So actually it is not so friendly to any kind of civil liability regime under which the particular investors as plaintiffs would go to the court to claim for compensation from the damages of particular insider tradings. So in this paper, we found out that inside the doctrinal debate, the core element of any reasonable or justified regime in China about the civil liability of insider trading should lay with the duty to disclose or abstain. And only with this duty can we justify the reasonableness of a already existing jurisdiction of insider trading. So we put quite a lot of ink in explaining this kind of duty as a integral conceptualization of the duty and try to explain the distinct normative purpose, and they integrated meaning of they abstain or disclose duty of the insiders especially. And in the second part of the paper, we made a comprehensive study of insider trading law models. We made research about the market protection model in European Union, in Germany, and in Japan. And as we find out, the market protection model in EU, as they put it, this model do not support any kind of civil liability regime in EU countries. Of course, insider trading or insider dealing is illegal in EU. That is for sure. But EU does not provide for any kind of civil liability regime for such kind of illegalities. And that is the same in Germany. As we found it out, the German regime does not support any kind of civil liabilities for insider dealing either. And it is very interesting that it is the same in Japan. Violation of insider trading regulations in Japan would constitute illegalities as a tort. That is for sure. But the major stream scholarships does not support the real possibility of application of the tort law provision under the Civil Code of Japan. That is to say, it's very hard or even impossible for the proof of causation about the insider trading as a tort. So it is actually impossible in Japan to claim for compensation for insider dealing or insider transactions as well. So that is market protection model. In our comparative study of different jurisdictions, it failed to provide for a meaningful model to support particular torts compensation about the insider dealings. And later we turn to the model of the US. We examine the fiduciary duty model, which is popular in the US under the Securities Exchange Act of 1934 and a series of very important SEC sanctions and Supreme Court cases. In the US, they found that the fiduciary relation gave rise to a duty to disclose because of the necessity of preventing copy insider from taking unfair advantages, blah, blah, blah. But such kind of fiduciary duty model is on condition of a fiduciary relationship. And it is right, such kind of model, quite debatable as well, and even criticized fiercely by the US scholars for themselves. And it is also not possible in China to use such kind of model because in China, we do not have such kind of fiduciary relationship between insiders and the investors under the PRC law. So we cannot produce a justification for the civil liability regime in China based on the model of the US either. So finally, we get to the core of this paper, and we argue that under China's securities law, there is so-called dual protection model, in which the securities law is over here not only for the purposes of regulating the securities activities and to safeguard the integrity of the market, but also for protecting the lawful rights and interests of the investors. And why this dual protection model is critically important for China to make it different from either the EU model, the German model, or the US model. And under this model, actually, we can argue, we can justify that the civil liability provisions can be justified because of such a dual protection model. We base our argument on the explanation of the provisions of the articles of the securities law and on the scholars until nowadays scholarships. We argue that we can see of insider trading civil liability regime from a duty perspective. Okay, so because of the time limits, I will not go to the very details of the whole argument process, and I will jump to directly to the conclusion. The conclusions of this paper would be, firstly, the rules of insider trading in China's securities law illustrate a dual protection model. So both the market integrity and investor protection are the objectives of China's securities law. Secondly, the legitimacy of a civil liability regime in China can be based on that dual protection model. Third, violations of the duty to disclose or abstain is a core element of China's anti-insider trading regime. And fourthly, civil liabilities for insider trading has only a complementary function to supplement the public enforcement. That means in China, the public enforcement of the securities law, especially in the area of anti-insider trading law, is the most important. So administrative sanctions by the CSRC as the market regulator is more important. Sometimes even the criminal law liability or criminal law penalties may be more important. But still, civil liabilities can act as a supplementary institution for the public enforcement. And in the end, I would say that when we are constructing the basic theories under China's securities law in this jurisdiction, in the past, we studied quite a lot from the scholarships and statutes and cases from the US. And in the nearer period, the local scholars also tried to draw lessons from the EU. But nowadays, perhaps at the same time, we should come back to the land of China to try to work out a local solution, local theoretical basics for the China institutions under the capital market law. So that is some kind of implication for such a very theoretical and local study about the civil liability regime in China. Thank you very much.
Thank you so much, Professor Tang, for the insight and very deep theoretical analysis on this interesting topic. So I think we still have some time for questions. I wonder if we have any questions from the audience, either here or online.
I actually have 3 questions for each of the speakers, as I did in the beginning.
Yeah, so if Professor Zhou, if you want to maybe ask those 3 questions.
Yeah, so I asked all 3 questions, so the speakers can also have some time to think about the questions. My first question is for Professor Shen, and it's a little bit controversial, perhaps sensitive question. One of the criticisms we have heard internationally in relation to the corporate reforms and also especially the SOE reforms is and the in the corporate in China, but that has been a concern internationally about the extent to which party sale or the involvement of party members in the corporate governance and decision making may actually affect the commercial decisions of companies. I wonder whether you can say a few words about it and how that aligned with the reforms of the company's law and perhaps implications for investing enterprises, which is the topic. The second question to Sophia, it talked about review consistencies and those kind of reform suggestions. So that kind of provoked me to think about the issues in relation to transparency, accountability, and due process in this review process, and especially in relation to the Chinese authorities. So I wonder whether you can provide a bit more detail about those perspectives and whether you have any suggestions for reform. The final question to Professor Tang, and I really learned a lot, so thank you so much. It's not my area. None of these topics are my area, but I really fascinated by your talk. My question is kind of goes into your theoretical explanations and also your discussion of different approaches. So I'm kind of seeing a mismatch between the theories and the approaches. If the theories are kind of the shared theories, approaches, especially in civil liabilities, or how they kind of cause the liabilities and damages to be compensated in different jurisdictions. I wonder why we have seen different approaches. if it were actually based on similar theories. And if you don't think that these theories, as you said, that these theories have their own deficiencies, you also said that maybe we should have a local theory. Can you elaborate a little bit about how the kind of the standard traditional theories have underpinned the different approaches taken by different jurisdictions, and what you're kind of suggesting about the local theory or new theory to facilitate the regulatory development in this area?
Tension and the policy. The policy is a very sensitive one because there is one chapter about the state-owned company. Some scholars argue that our company law is only regulating the commercial matters, is not about political matters. But in the environment of today, we can't pull the political and the party matters away from the company law. Like in the amendment draft, there will be one article is about the party, the law of party in the company law, but we restrict the article in the chapter of state-owned enterprise. So in words that the party don't influence the other kind of companies. I think that's a good way to deal with the law of party. We only restrict the party law in the state-owned enterprise.
Thank you for the questions. In terms of review consistency, transparency, and due process, I would like to answer it one by one. For consistency, one way is to, I think in Australia in 2012, Productivity Commission conducted called a leading practice review, which identifies different approach of how each jurisdictions conduct a review. And the purpose of this report is to identify leading practice. So different jurisdiction, they have their different circumstances. It's now clear cut, but they can learn from each other. So I would say maybe in China, we could think of like some sort of like benchmarking reports led by competition authority to address this inconsistency issue, or try to identify the leading practice that could help local government to improve their process. For transparency, what I mean in my presentation is mainly on the exemption case. Although the regulation specifically said if you grant exemptions on on fair competition review, or if you decide policy that is now that should be exempted from fair competition review, you need to document it, you need to explain the reason, and you need to publish online. And to my best knowledge, such publication is very hard to locate. I think sometimes due to the sensitivity issue of the case, which is understandable. But I would say a list of granted exemption case published on the website, along with the other published report on fair competition review, would be helpful to increase transparency. And also for due process, this is in the context of fair competition review. Due process refers to who drafted this policy will review it. So within government, some government have a dedicated unit to conduct such review. It's separated from the drafting policy. Some government doesn't. It's basically, I draft it, I review it. So the review process need to be reconsidered, and maybe better to have a separate unit to review such case. That's just my suggestion, my way, I think that could be the solution. I hope this answers your question.
Thank you for your question, Professor Zhou. When we began this research about the reasonableness or justification for the already existing civil liability regime under the PRC circus law, is that when the law itself was drafted as early as in 1999, that was quite a long time ago, especially for a emerging market like China. And after the first revision in the year of 2005, there was such a civil liability provision under the law. But we can imagine that the provision was transplanted from the US circus law, because quite a lot of scholars in the area of capital market law and also the legislators themselves would be comparatively familiar with the experience in the US. Both the settler law and the very important, well-cited cases of the US Supreme Court. And at the same time, the legislator would think that civil liability would be one part of a advanced jurisdiction of capital market law, because under such kind of law, the interests and the rights of the investors would be protected. So it is kind of private enforcement of law instead of a pure public enforcement of law. So that is why the legislator think, I should say, sought at that time a civil liability regime was necessary. But the problem is, under the law, such kind of regime was not quite well explained. And that is one of the reasons why today so many strong scholars, especially young scholars, would argue against instead of argue for the justification of this regime. So the aim of this paper and the research is try to find out the so-called local resources of the rule of law. In Chinese language, we would say the 法治的本土资源, something like this. We try to explain why the models of the other jurisdictions would not be feasible and or justified on the soil of PRC. We found out that in some countries, especially in the EU countries, including but not limited to Germany, they don't support civil liabilities of insider dealing at all, because they think that.
So, there is a couple of issues. Firstly, from you, but the only thing is such a limited. I can speak, I can answer as we try to find some local resources. The second thing,
thank you so much. This is and I think with that really is good notes to end our session, which is on the recent development of China's approach to the domestic economic governance, concluded that it's really important also to draw on, to draw on experience in our decisions, but they don't always work in the domestic context. It's very important to look for the domestic resources. So that's probably a good note to end our session today. And thanks everyone, thanks to all our panel for the very excellent presentations, and thanks for our audience online and for joining us. And so we conclude the session now. Thank you, everyone.